Joining us on 710 KURV, he's called the patent professor, John Rizvi, joining us. Cyber squatting, people who just buy up a bunch of domain names and they just kind of hold them over somebody's head that kind of wants it. But I think you have more of a textbook and legal definition of what this actually is. Welcome, Mr. Rizvi.
Yes, how are you? Always a pleasure to be here.
Well, we're talking about the so-called cyber squatting and the legality behind this, where people can just buy up a bunch of domain names and just kind of, or just, how does the process work? Let me ask you.
Yeah, so, some would like to call it domain investing because there's a law passed in, 1999, in fact, it's been quite some time. It's the Anti-Cybersquatting Consumer Protection Act that prevents bad faith registering of domain names with the intention to sell them back to the rightful owner. So there is illegal cybersquatting, and then there's domain investing, and they're two different things. And sometimes it's hard to tell when someone is kind of skirting the line between legitimate investing in domain names that they believe are going to be valuable someday, and versus registering domain names that contain, trademarks or the names of legitimate businesses. Now, this is a unique niche, so to speak, of registering potential candidate names that this one attorney, Jeremy Etchie, believes that names that he believes are going to end up becoming popular and candidates that are going to win. And he has an amazing track record because he also purchased back about several years before the 2016 election, ClintonCain.com, banking on the fact that Clinton would choose Virginia Senator Tim Kaine as her running mate, which she did. So he did purchase that domain name. He offered it to the Clinton campaign, and they did not purchase it. In fact, they offered $2,000. So he ended up selling it to an anonymous purchaser, which later on turned out to be the Trump campaign. So these things do get dicey at times.
I think, if I remember correctly, Trump had bought some domain names of his opposition in the past, and I can't remember which one it was, but it had led to it was either him or one of his allies, and it had led to a completely different website with all the talking points against the candidate.
Yeah, I mean, if I can say so myself, it was a brilliant move on his part. He purchased JebBush.com, and at that time it was a huge oversight by the Jeb Bush campaign to not have purchased his own name, to not have purchased JebBush.com, and then Trump ended up registering it and and using it for his own campaign to basically show his base why, or those that are for Jeb Bush, mistakenly going to that website and then trying to convince them to vote for him instead.
Joining us on 710 KURV is John Rizvi, the patent professor, joining us on 710 KURV. We are talking about how cyber squatting works, where people buy domain names. If I remember correctly, I think something similar had happened to Meta and the Zuckerberg. He was trying to launch Meta, and as it turns out, I think Meta.com had been bought by some other guy, and he wanted like $1 million for it.
Yeah, so it is, I mean, it's used to be a lot more common, of course, before the Anti-Cybersquatting Consumer Protection Act, which is a mouthful. So I call it the ACPA, which is commonly known as. That makes it a lot harder when there's trademarks that are registered. Then you have a much tougher case. Now, in situations such as this with candidate names, it's a tough call, because under the ACPA, there's 9 different factors to try to show bad faith. So it's bad faith registering of a domain name. Now, one factor that's majorly in favor of this attorney registering, and others that are dabbling in trying to predict candidate names, and that's timing. They are registering these domain names at a time when there's no value to them. There's, in fact, he registered this one, the Harris Walls.com 5 years ago, way back in 4 or 5 years ago. 2020, I believe, is when it was registered. At that time, some are calling it incredible foresight, because there's, to think that that Harris and Walls are now presidential and vice presidential candidates, to have predicted that back in 2020 is just remarkable. And if it was, they say lightning, never strikes twice. But in this case, he also correctly predicted the Clinton-Kaine candidacy back in 2016. So there's, now of course he's purchasing a lot of other domain names, so it's not as if he's got 100% accuracy. I believe he purchased 15 or so different variations with Kamala Harris's name in it. So it's not as if they were, so that means 14 or so he was wrong on, but he only has to be right once, and he successfully sold the domain name to an anonymous purchaser, so we don't know who it is, but for $15,000 it was sold yesterday and purchased for $10. So it's an incredible windfall for him.
It's so cool. It's like winning the lottery. John Rizvi is the patent professor joining us on 710 KURV. So, I mean, if stories like this get taken to court, I mean, they can kind of tell whether it's in good faith or not, that if a person owned a domain name for a certain amount of time before it was wanted by, say in this case, the Harris people, a court would rule in his favor. Is that right? But if it was bought like 20 minutes ago, they would rule against him.
Yeah, exactly. But part of a big factor is, like I said, timing. So it's different if a cyber squatter or domain investor, if they take a registered trademark, a company that just happened to not protect their trademark, and they register that afterwards, after the company already exists, which is what happened with a lot of the early cyber squatting cases. Like someone had registered McDonald's.com, and clearly McDonald's had prior use and had a trademark, but they weren't sophisticated enough at that time. They didn't have the legal counsel, or they just didn't register their trademark as a domain name. And a lot of companies were failing to do that, and cyber squatters were snapping up the domain names, holding them hostage, and trying to sell them back to the rightful trademark holder. Now, this was prior to the ACPA, the Anti-Cyber-Squatting Consumer Protection Act, which now provides statutory damages for anyone that in bad faith, without a bona fide prior use, registers a domain name and then tries to sell it to the rightful trademark holder. You can't do that. This is, kind of a gray area, because there's no registered trademark to Clinton, Kaine, or Harris either, or HarrisWalls.com either. There's no registered trademark and no trademark rights. And in fact, at the time this domain name was registered, there was no ticket with Harris and Walls. In fact, it was way back in 2020. So that's where I say the incredible foresight of registering these well in advance.
That sounds like something that I'm going to get into for the next one in 2028. I'm just going to start going down the line and start buying them all up. It's not cheap, though. I admit that. John Rizvi, the patent professor, thanks so much for your time as usual, joining us on News Talk 710 KURV.